right, I call this meeting to order. First of all, it's a pleasure and honor to be here as your vice chair chairing this meeting. Thank you all so much. Welcome to meeting 37 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference of the House of April 20, 2026 and the motion adopted by the committee on April 30, 2026, the committee is resuming its study of Bill C-22, an act respecting all lawful access. Bienvenue to our witnesses. We have Professor Leah West as an individual. Welcome. We have Chief of Police for Thunder Bay, Chief Fleury. And we have Chief of Police for the Toronto Police Service, Chief Demkiw. Welcome to you all. You all have 5 minutes to make an opening statement. For those in person, I will endeavor to try to get your attention when you're at 1 minute and then when we're coming down to the time. And hopefully I can do that as well for the people that are by video link. With that, I invite Professor West to make an opening statement. Thank you.
Chair, members of the committee, thank you for the opportunity to appear today. By my count, Bill C-22 represents Canada's 9th attempt to enact lawful access legislation. That alone should give us pause. For over a decade, successive governments have recognized the same problem. Our laws have not kept pace with the realities of modern criminal and national security threats or the tools required to address them. The result is a growing gap between Canada's lawful access framework and the central role electronic data plays in investigating and prosecuting crime. At the same time, the Supreme Court of Canada has been clear that even basic identifiers can reveal deeply personal information and are therefore protected under Section 8 of the Charter. As the court recently reaffirmed, an IP address is often the first digital breadcrumb that can lead to the state on the trail of an individual's internet activity. The government and this committee have a difficult task: to address the existing operational gap in a way that is consistent with the Charter. Bill C-22 is a meaningful improvement over past efforts at reform. It reflects the hard work done by officials at Public Safety Canada to engage with stakeholders and revise earlier proposals. It is more carefully structured and, in my view, capable of getting us to a workable lawful access regime, but it is not there yet. Let me briefly highlight 3 areas where targeted amendments would significantly strengthen the bill. First, the Subscriber Information Production Order. The bill introduces a new tool that allows police to obtain subscriber information on a reasonable suspicion standard. In my opinion, that standard is constitutionally defensible, but the bill as drafted goes too far in another respect. It requires service providers to produce all subscriber information as defined, tied to an identifier, regardless of whether each category of data is actually relevant to the investigation. This new power applies to anyone who provides services, not just telephone service providers, creating a risk of overcollection of private information that does not meet the legal threshold set out in the bill. The fix is straightforward: amend the provision to give police the discretion to request and judges the discretion to authorize only specific types of subscriber information for which the standard has been met. If the standard for a production order is going to be suspicion, then the scope of what is authorized must be narrowly targeted. Second, risk to individuals in foreign jurisdictions. The bill allows Canadian authorities to request data directly from foreign service providers. This power is important, but it carries risk. There is currently no requirement for a judge to consider whether such a request could expose the target to mistreatment in another country, and that is a gap. I recommend adding a clear obligation for judges to assess whether there is a substantial risk of mistreatment and to refuse the order where such a risk exists. This would align the regime with Canada's broader human rights commitments and what is already obligated for RCMP officers under the Avoiding Complicity in Mistreatment by Foreign Entities Act. Third, and most critically, Part 2, or the SEA, which is what I'm going to call it, requiring companies to build interception capabilities and retain data that they would not otherwise keep inevitably creates cybersecurity risks. Every additional access point, every new repository of data is a potential target. The question is not whether the bill creates new risks. It does. The question is whether the bill adequately mitigates those risks and strikes the correct balance between the risks and the public safety imperative. As currently drafted, I don't think that it does. 3 changes are essential. First, strengthen the definition of systemic vulnerability and prohibit the GIC from weakening that definition through regulation. Second, prohibit blanket data retention. I believe the current authority engages the right to privacy as overly broad and creates a significant cybersecurity risk. The current 1-year framework departs significantly from existing 90-day preservation limits, and I've yet to hear a compelling argument for the need for a blanket retention obligation not tied to any specific collection authority or subset of offenses such as serious crime. Any retention regime must be necessary for investigative purposes and must be reasonable and proportionate to the offense or threat under investigation. Third, make explicit that law enforcement and CSIS cannot directly collect or intercept personal information or private information from service provider systems. Control over access to providers' data and systems must remain with providers. They alone should flip the switch. This is critical for privacy, security, and legal clarity. In conclusion, I believe deeply that Canada needs lawful access reform. But the task is not simply to expand access. It is to ensure that any expansion is necessary, reasonable, and proportionate, that it does not undermine constitutional protections or create undue security risks for Canadians. Bill C-22 is a meaningful improvement, but targeted amendments are still required to get this right. Thank you.
Thank you, Professor West. Perfect time. We will now move on to Chief Fleury. You have 5 minutes. Thank you.
Thank you. Chair, members of the committee, thank you for the opportunity to speak with you today about Bill C-22, an act representing lawful access and why policing leaders across Canada strongly support its passage. Policing in Canada has changed dramatically over the past decade. Crime is no longer confined to physical spaces or geographical borders. Today, organized crime networks appear across jurisdictions using encrypted applications, anonymous accounts, and digital platforms to coordinate activities such as drug trafficking, human trafficking, firearm smuggling, and cybercrime. Yet the laws that govern how police access critical information were largely designed before the digital reality existed. Bill C-22 is about closing that gap. It processes practical, measured updates that would allow investigators to access certain information more efficiently, always with lawful authority, judicial oversight, and a full respect for the Charter and the privacy protections Canadians expect. This is not about expanding unchecked powers. It is about ensuring that when police have lawful grounds to act, they can
one
do
moment,
so
please,
in a timely
Chief.
way.
Just if I could interrupt you, please. If you could please take the boom of your microphone down just a shade so that it's not touching your skin, please.
Oh, okay. How's that?
I think that if you could actually just do a test.
If you could just do a test 1, 2 for us, please, just to make sure. It's. I think it's probably hard on the interpreters. So if you could just do a test.
Test 1, 2. Test 1, 2.
Yeah, they're getting.
Yes, thumbs up. Thank you. Sorry to interrupt you.
Okay. No, that's good. Thank you. This is not about expanding unchecked powers. It is about ensuring that when police have lawful grounds to act, they can do so in a timely way, especially when lives are at risk. We are experts in this area. Last year alone, the Thunder Bay Police Service investigated 184 cyber-related cases. This involved more than 140 production orders and 80 search warrants, and over 1,370 devices being seized for examination. These efforts led to 20 victims being identified and more than 240 charges laid. This is impressive for a 5-person unit. But this is not about statistics. It's about protecting people. The Bill C-22 will help services like ours facing increasing demands with limited resources reach victims more quickly. Let me illustrate this in a more realistic scenario. Imagine a missing 14-year-old girl, Shauna. Her parents report that she has been communicating online with someone they believe is exploiting her. Investigators identify a username linked to her messaging platform. Time is critical. Under the current framework, confirming which service provider holds that account information and obtaining the basic subscriber data needed to proceed can take valuable hours or even days due to fragmented processes and outdated legal pathways. Meanwhile, evidence suggests the suspect may be attempting to move Shauna across provincial or international borders. Every hour matters. Under Bill C-22, investigators can more quickly confirm the service provider tied to the account and proceed with the appropriate judicial authorization to obtain further evidence. In urgent circumstances, they could request limited emergency access to data to prevent imminent harm while remaining fully accountable to strict legal thresholds and oversight. That time saved could mean locating Shauna before she is moved, before further harm occurs, and before critical evidence disappears. This is the reality police services face every day. We have multiple examples in Thunder Bay where we have youth as young as 14 coming from being exploited and coming to our community from Southern Ontario. The Canadian Association of Chiefs of Police has endorsed Bill C-22 because it strikes the right balance. It streamlines access to essential information, improves emergency data sharing, and clarifies voluntary disclosures while maintaining strong judicial and privacy safeguards. The Ontario Association of Chiefs of Police has also consistently called for modernizing lawful access tools. Our members see firsthand how individuals and organized crime group networks have exploited legislative gaps. These actors are sophisticated and constantly evolving. To keep communities safe, policing must evolve as well. Lawful access tools are not about surveillance or reach, they're about public protection. They allow investigators to understand criminal networks, prevent violence, and rescue victims. Whether it's locating a missing youth, disrupting fentanyl trafficking, dismantling human trafficking networks, or combating online exploitation, clear legal frameworks and modern tools are essential. Bill C-22 represents an important step forward. It acknowledges that modern crime requires modern solutions. It ensures police can act quickly in urgent situations while remaining firmly grounded in judicial authorizations, privacy law, and the Charter of Rights and Freedoms. At its core, the legislation is about protecting Canadians, especially the most vulnerable among us. I urge and support you to support the timely passage of Bill C-22. Thank you.
Thank you, Chief Fleury. Now we will go to Chief Demkiw for 5 minutes, please.
Thank you, members of the Standing Committee on Public Safety and National Security. Thank you for the invitation today to join you. The Toronto Police Service, along with the broader policing community in Canada, has long advocated for reforms that put public safety first, including reforms related to lawful access. We believe that Bill C-22, an act respecting lawful access, is a step in the right direction. It will provide additional tools for our officers to be able to move investigations forward more quickly, hold offenders accountable, and prevent harm. Preventing harm often requires the ability to intervene early, including in cases involving violent extremism. The Toronto Police Service is the biggest municipal police service in Canada. Policing in Toronto is extremely complex. In addition to all the unique aspects of the city, we often see trends here before they begin to appear in other areas. We see the ripple effects of geopolitics and a rise in hate crimes. We see frontline situations rooted in the complexity of mental health, addiction, and unmet social needs. Toronto is home to the majority of councillor offices in Ontario. The city is host to many major international events. We are seeing more young people becoming involved in violence, often communicating anonymously about potential targets through digital platforms. Addressing these issues requires support and collaboration across the broader justice system, including through legislative reform. In many ways, new technology and communication enhancements have made our lives easier, but they have also made it easier for criminals to plan their activities and avoid justice. We are seeing bad actors use digital tools for all kinds of crime, including drug trafficking, extortion, child pornography, hate crime, extremism, and other serious offenses. Our role is to prevent these offenses, to bring offenders to justice, and to provide a voice for victims who have experienced some of the most difficult circumstances. However, because technology has evolved so quickly in recent years, we are encountering roadblocks in some of these investigations. Take, for example, the issue of confirming which telecommunication service provider has information that will assist in an investigation. Presently, this process is time-consuming and potentially leads to loss of evidence. Bill C-22 will streamline our processes and allow police to advance investigations in a timely manner. As the criminal world evolves, law enforcement and the justice system must keep pace. It is important to note that some of these tools are already available in other Five Eyes countries. The Toronto Police Service strongly believes that lawful access will reduce delays in accessing critical information and, in doing so, enhance public safety. Thank you, and we look forward to continuing our work with all levels of government to ensure the justice system upholds accountability and protects our communities.
Thank you, Chief Demkiw. With that, we will get to our first round of questions, and I will exercise my prerogative as chair to take 6 minutes for questions. This is something I've spoken with the Honourable Parliamentary Secretary and my colleague from the bloc about. Thank you all for being here, and this is an area in which you all have a lot of expertise. Thank the two police chiefs for their service. Professor West, it'll probably be no surprise. I'm going to start with you with our questions. We spoke sorry, I'll just restart the timer there. If we could just restart the timer for mine, please. Professor West, I wanted to ask you about encryption. This seems to be, for some people, a really big issue. Does the bill, what can you say about encryption when it comes to this bill? As in, is it sufficiently defined? Is it not sufficiently defined? What, in your legal opinion, where, in your opinion, would you land, given what we see in the bill on the definition of encryption?
So as far as I read the bill, there is no means by which the government could say you have to force open your encryption if you don't already have the capabilities. And I say that because both for the regulations and for the ministerial orders, it says that you cannot require or you cannot comply with an order or regulation if it requires instituting a systemic vulnerability into your system. And the way that systemic vulnerability is currently defined includes encryption because of the definition of electronic protections. So my concern is more over the fact that there could be other forms of systemic vulnerabilities built into the hardware or operating system that don't get captured by the definition of systemic vulnerability, and that's where I see a gap.
Okay, so I'm going to have you expand on that, please. When you talk about these vulnerabilities, I assume these might be vulnerabilities that the provider might not even know about. Is that accurate?
Correct, but because we don't know who a core provider would be and who could be captured by this act, there could be hardware providers, for example, who could be service providers who would be captured, and the definition of systemic vulnerability as it stands wouldn't capture their activities. And I know you're going to hear from Professor Diab later, and he also has thought about this as well, so I'd turn to him more on that.
Right, because in the legislation, the bill would, Part 2 would apply to those who are defined as core providers or who meet the definition of core providers, or, if I recall correctly, those who are designated by ministerial order. Is that
That's my understanding, yes.
So theoretically, somebody could be designated by, or a business could be designated by ministerial order, and they would then be subject to this. So it's essentially, if I get what you're saying properly, that's kind of boundless or limitless in terms of we don't know exactly who this is going to be applied to. Do I have that right?
Well, my understanding is that they would still have to be an electronic service provider, but the definition of electronic service provider is fairly broad, so it could capture people who provide hardware services, for example.
So I'm going to ask you, this is an interesting question that was brought to my attention. Let's say a business provider has a capability, Alexa, for instance. I think that's the Amazon. That's Amazon, I believe. Is that right? Something like that. Alexa theoretically could listen to your conversations, or every time you say, "Hey Siri," Siri starts to listen, right? So could it be possible that if Apple has the ability, and sorry to pick on Apple, but if anybody has the ability, any company has the ability, that they could say, okay, every time you say, "Hey Siri," that has to start listening. That app has to start listening, and the app itself or the provider itself has the ability to listen, right? So it's actually not necessarily it's not asking the provider to create a new power. It's almost asking for it to go one step further. Are you with me so far?
Yes.
And as I understand it, if such an order was made, that order would not possibly be secret. That would be secret. In which case, a whistleblower couldn't necessarily come forward. I guess the only recourse there would be for the company who is doing that to apply for judicial review. Is that accurate?
So if there was a ministerial order to have that capability, that ministerial order would have to be reviewed by the IC and approved. And then, yes, with consultation, there's consultation built in to require that consultation with Apple in this case. But if that approval was still done, then there would be JR. But then on top, you have to layer on top of the fact that nobody could access that lawfully without a warrant for interception. So just because the service provider wouldn't have the capacity doesn't necessarily mean that the law enforcement would then all of a sudden have access. And if in that case, you wouldn't really be instituting a new vulnerability because they already had the capacity. So really, you're just giving law enforcement the capacity to tap into something that already exists if they had lawful authority.
Right, and I suppose in this case, I guess the difference might be that the police could say, we believe Professor West has committed a criminal offense and that, her use of Siri holds evidence of that. We are going to get a warrant that does this. They could get that now. The only difference is that under Part 2, there would be a requirement to bring up the capacity to do that or the capability to do that, whereas right now it would just simply exist, if that makes sense.
That's my understanding.
Okay, thank you. My 6 minutes are up. Monsieur Ramsey, vous avez 6 minutes.
Okay. Donc ma question s'adresse.
My question is for our two police chiefs. One of the things we have to keep in mind and keep in perspective is that Bill C-22 would give law enforcement authorities to act in a timely manner. And Chief Demkiw, I think you mentioned that it was otherwise time-consuming. There was a potential loss of evidence. But what I'd like to hear from you is in the case of internet fraud or cyber criminality, extortion, or vehicle theft, am I correct in thinking that acting quickly, instead of talking about dozens or a few cases, if an investigation lasts 12 to 18 months, could this involve hundreds of victims? And in the case of cyber criminality, sextortion, we're talking about a lot of victims here. So I'd like to clarify that with you. There is a big difference between having one victim versus 200, or one case of cyber criminality versus 12. And this is where C-22 is supposed to make a difference.
My question, and the short answer is yes, time is of essence. And whenever time is of essence in cyber criminality, fraud, or extortion, you certainly risk greater victimization, both by the number of victims and by the impact on individual victims. As we know, sometimes people are victimized many times over. And to your point, as our investigations are sometimes hampered and take longer to unravel the digital evidence that needs to be uncovered to stop the victimization and criminality, more victims happen during that time.
Chief Fleury, would you like to add to this?
Yes. So just maybe in the example you used on fraud, for example, fraud-related offenses, let's think of an example of a Ponzi scheme. in a Ponzi scheme situation, if we have one victim or two victims or three victims that we've identified, and we're able to get into that material and get into that information early on, there's a really strong possibility that the quick access to that information will stop further victimization or other people becoming victims before we have an opportunity to finish up the investigation. And I have seen that happen in the past where time is of the essence when you're talking about these people are very motivated into doing their crime, and they will multiple victims very quickly. If we have the ability to get in there, might be able to interrupt some of the activity while we're forming grounds to lay charges and proceed with the court proceedings. So I think it's really important to have that early access on those types of scenarios.
Thank you. L'autre point, c'est que des fois...
The other point is this. Sometimes we have the impression that some people think C-22 goes too far. However, with C-22, the government really showed a lot of discipline and focused on what was essential. At a certain point, there was talk of requesting information on vehicles, taxis, and even from hotels, but the government decided to not include the coverage of those things. Do you believe C-22 is well calibrated and is only looking for the obtention of essential information?
If I may start, the short answer is yes, I believe it is. It's, we know from practical experience, the use of digital technology by the criminal element has expanded dramatically, and our ability to gather timely evidence and preserve evidence and prevent the escalation of offenses is hampered by the inability to access key digital bits of evidence, and C-22 will assist us in that regard. I think just by way of a simple example, having a phone number tied to a particular set of criminality, no matter how serious the alleged crime, we have to establish who the service provider is. And that in and of itself is a cumbersome task today, where C-22 will streamline that and allow us to move more quickly, gather essential evidence that may be disappearing and lost while we wait for different service providers to advance our investigations through the current legislative framework. So C-22 is calibrated well to assist us in making access to key digital technology in a timely way more readily possible.
Yeah, and I would agree with Chief Demkiw. I think it's very, very well put together, and it does address those areas that are, data moves so quickly that I think it does a good job at collecting that.
Mrs. West, I believe when it comes to electronic protection safeguard, I believe Canada with Australia are the only countries where there's explicit prohibition against electronic protection safeguard implementing a capability that would introduce a systemic vulnerability. For instance, in the USA...
Désolé, Monsieur Ramsey, your time is up. And no, I didn't look forward to saying that. Madame de Belfay, vous avez 6 minutes.
Oui, Monsieur le Président.
Thank you, Mr. Chairman. Ms. West, Professor, in a joint letter, several organizations from civil society expressed concerns that Bill C-22 might make it easier to exchange information with foreign governments, including with states whose human rights practices raise concerns. What additional protections should be considered to limit another use of the information of Canadians?
I think there's two issues. The first is on the changes to the MLAT, which would allow foreign entities to serve orders on Canada, and then through the process of the minister approving the request, going through a judge, and then the judge agreeing that the criteria made out in the criminal code are met, and then collecting that data back. Now, there is no requirement that the law for which is under investigation be a crime also in Canada. So there is the possibility that you could see foreign governments seeking to enforce repressive laws or politically motivated investigations through this process. And there's no real safeguard for that, but for the actions of the minister and him executing his discretion. And so I think in this case, especially because there's not a judge necessarily involved in the foreign jurisdiction, it can be an administrative order, the minister has to commit to exercising his discretion to not authorize the process where there is potential that the crimes being investigated are repressive or politically motivated. There's no safeguard in the law. They could, by adding the fact that the law would similarly have to be a crime in Canada, and then we wouldn't have that problem. So that's one way to make it broader. But as of right now, it would be at the minister's discretion, I think.
Merci.
Thank you. This is something I worry about a lot. If you could suggest a specific amendment to the bill to reassure the people who raised those concerns with us, that would be very helpful. You would have until May 27th to table any amendments you think are necessary. Now, you wrote a letter to the Globe and Mail where you said the work of this committee was very important and finding a consensus around the bill is also very important. I think everyone around this table believes C-22 is necessary, but perhaps it could be improved. So do you believe it would be reasonable to add the National Security Surveillance Office and that it be informed in real time when a ministerial order is emitted to conduct an investigation to make sure there's no abuse?
No, I don't. I think the National Security Intelligence Review Body is a review body. It engages in ex post fact review. It doesn't have a current mandate where they're actually engaged in oversight right now. The body that we have, and I personally recommended that the Intelligence Commissioner should be involved in reviewing ministerial orders because they have that role of oversight in the current system and they're set up to do that in a way that INSIRA is not.
Parfait. Alors, l'idée étant que...
The idea being not that the agency be involved in the decision, give its opinion, whether yes or no the ministerial order should go ahead. But perhaps it could be notified in real time to keep a record so that if ever there is an investigation, you could go back and look at that record. Can you be a little more specific? Because I might have misunderstood because of the interpretation.
So I certainly see a role for INSIRA in reviewing the system in general, and potentially a role for your colleagues on NSI COP here down the road. And I think that will be exceptionally important, in particular looking at how the role of engagement with the service provider community is rolled out. Whether or not INSIRA needs to be informed every time there's a ministerial order in order to do that, again, I think they're more set up for a longer-term oversight, or longer-term review, and they would be best, receiving information at the end of a calendar year or every 6 months. I don't really think they're in a position to do case-by-case review.
Parfait. Pourriez-vous, vous avez parlé que la définition de fournisseur
You spoke about the definition of electronic services provider. It's a very broad definition. It could include equipment manufacturers or providers. Can you give us some concrete examples of these equipment providers?
Sure. I mean, really anybody who provides electronic services often provides, anyone who provides hardware often typically also provides some sort of electronic service. I think hardware providers like Ericsson and others who operate in the hardware space could find themselves captured by the broad definition. I don't think that's necessarily wrong. I think that the definition...
I'm sorry, Professor, we'll have to pick that up in the next round, and we will move on to Ms. Kirkland for 5 minutes, please.
Thank you. My questions will be for Ms. West, and I appreciate your testimony here. Given this is our 9th time, as you said, you believe, trying to get this legislation right in terms of lawful access, how important is it that you said strike a right balance, right? How important is it that we're not racing to royal assent and that we are taking the time to review amendments and listen to testimony?
In my opinion, it's crucial to getting the bill right.
Thank you. We know that you have said publicly that the government should show its homework, and I appreciated that, especially to folks on this committee who are part of making this legislation go through this process. We know that in consultation with Murray Rankin, he produced a report which informed Bill C-22, and the Minister of Public Safety told the committee that the report was used specifically to inform the government's decision-making on C-22, and I know you participated directly in that consultation. In your professional opinion, is there any legitimate national security, solicitor-client privilege, or operational reason preventing the report from being released to Parliament or the Canadian public?
I'm not privy to the relationship that Murray Rankin had with the minister when he offered his advice, so no.
Okay. From your perspective as a participant in the process, how central was the consultation exercise to shaping the lawful access now before Parliament?
In my opinion, it reflects the type of advice I was hearing as part of the consultation process.
Okay, great. To your knowledge, were participants in the consultation process ever advised that the report or its findings would remain confidential from Parliament?
That wasn't something discussed.
You never discussed that? Okay, thank you. So without actually, just one more question. In your experience, is it typical? I mean, you've probably been part of these processes before. I assume you have been. I could be wrong. Is it typical for consultation reports involving external experts and stakeholders to be withheld entirely? Have you seen that before?
I've never been involved in a consultation that was run by an external party before, so I'm not sure. Typically, I've been involved in consultations that are run by the government themselves.
If I could just interrupt for just one moment, please. We have a meeting here. I don't mind whispers. I know that's going to happen, but I would just, if it doesn't need a meeting, we should go outside, please. Thank you.
That's all right. I've never been involved in a process similar to this. In the past, in government consultations, I've seen, what we heard reports been published, but this was a different kind of process.
Okay, I think it sounds like in part of the process, you may have seen the report. Can you comment on whether it would be helpful for us?
I didn't see the report.
Oh, okay.
I saw a list of recommendations.
Okay, so you saw the list of recommendations. Without disclosing anything confidential that you may have seen, can you tell the committee whether the report reflected a diversity of views? Do you know if there were recommendations including concerns and cautions raised by experts and stakeholders in terms of privacy?
Yes, because my own concerns were reflected in the list of recommendations.
Okay, thank you. Beyond that report, I would just like you to expand a little bit more on the specific recommendations you have for amendments. If you could just take one or two that you think would really make this bill a much better bill. We're not arguing that lawful access isn't. I mean, we know lawful access and how important it is, and I appreciate the chiefs on the call or on the meeting as well today because of how important it is. Can you just give us one or two amendments that could seem fairly simple and that you think we could all agree on in order to get this right versus racing?
Yes. As I mentioned, I think I would implore the committee to hear from technical experts who know better than a lawyer how to capture all of the type of vulnerabilities that you would like to avoid in the definition of systemic vulnerability. I also think the currently, as drafted, the retention provision is overbroad. We've seen similar provisions, actually even more narrowly tailored ones in Europe, be found to engage the right to privacy and be unreasonable. I think that amendment or that provision in and of itself needs to be reformed to ensure that any regulation is narrowly targeted, necessary necessary and proportionate, and that reflects the seriousness of what they're asking for, which is the creation of large pools of private data.
Okay, thank you. Because we know that broad definitions often lead to future governments misusing or abusing legislation.
Fortunately, Ms. Kirkland, your time is up. And up next is Madame Akan pour 5 minutes.
Thank you very much, Mr. Chair. And Dr. Leah, it's great to see you again. So my question to you will be on the foreign entity request. Canada is currently the only Five Eyes and G7 member without modernized lawful access legislation. And does our lack of a technical capability framework hinder our ability to cooperate with the international partners on transnational threats? And how does Part 1's new mechanism for foreign entity requests solve this problem?
Yes, it does. My understanding, looking at and talking to folks across the Five Eyes, is that in other jurisdictions, the threshold upon which they can obtain subscriber information is lower than that in Canada. So often it's not required to be judicially authorized, or it might be on a reasonable suspicion standard, or even lower than that. And so when they try to serve Canada, or try to use the MLAT process in Canada, there's no parallel in Canada that would allow us to enforce their orders. So by having a new provision that's focused specifically on subscriber information and transmission data with a threshold of reasonable grounds to suspect, it would allow us to partner better with foreign jurisdictions, because it would be more in line with how they obtain subscriber information in their jurisdictions, and allow for kind of equitable enforcement.
Thank you very much. So I'll focus on primarily on the operational side of policing and ways to support the work that the investigators do when it comes to combating organized crime, extremism, and child sexual exploitation and other complex crimes. Chiefs, Bill C-22 creates a confirmation of service demand, which simplifies the process by which law enforcement identify the proper recipient of a production order. Would you say this helps in the context of a time-sensitive investigation dealing with organized crime, extremism, hate, or child exploitation? And how does it provide main operational benefits to you? We can.
Thank you for that. I think the practical reality is we often have a phone number or other clue that requires us to then pursue the digital footprint, the digital evidence that that phone number or other information provides. And in the present regime, there is no provision for us to make a demand for service providers. We have to do production orders multiple times to simply identify that this is a service provided by a particular telco, for example, and there's an incredible amount of time spent doing that. Just by way of example, numbers-wise, over a 20-month period, our detective operations alone in Toronto did 1,900 production orders. And something that would help us very much is to have the ability to understand which service provider to focus our investigative efforts on, and then pursue that through a judicially reviewed process of production orders or warrants. And that saving of time is very real and very much will impact our ability to succeed. The type of evidence that can get lost while we determine who the service provider may be, video evidence, forensic evidence, and as was asked in the previous question, may involve greater victimization or ongoing victimization that proceeds for a longer period of time while we in the present regime determine who the service providers are. So the ability to know where to focus our investigative energy quickly and then go through the process of gathering evidence through production orders, which is scrutinized by justice, is something we very much welcome.
Thank you very much. So in this context, Bill C-22 has metadata retention requirements where core providers are keeping this, metadata is to be held for up to 12 months. And yesterday we heard from officials that in Australia they keep it for 2 years, in UK they keep it for 1 year. Would you say that requiring core providers to retain metadata for 12 months is a reasonable time frame, given the fact that how quickly providers may otherwise delete the data? Sometimes it's 30 days, sometimes it's 3 months, while still remaining flexible for providers and supportive of investigators, especially when some complex cases can go beyond 3, 6 months, or even like over a year.
Well, maybe I'll start with this one, and maybe the chief can follow up. But yeah, I think 12 months is a good start. But obviously, yes, you're right. If the investigations are prolonged, and they can be very long in some of these cases, then retention beyond the 12 months, 24 months, 36 months would be ideal. I think maybe that's something.
Sorry, Chief Fleury, but we have to cut you off there. I apologize.
Okay. No
Next up, Madame de Belfay pour 2 minutes et demie.
For 2.5 minutes. Thank you, Mr. Chair. Professor West, you heard the 2 police chiefs talk about how long data should be kept. You said a year is too long. But in light of what the police chiefs just said, a year is the minimum. 2 or 3 would be better. How do you see that? Do you feel data should be held for less of a long time? Do you agree or not with the other witnesses?
I certainly understand from a law enforcement perspective why they would want all of the data that they need to be available for as long as necessary. But in terms of charter protections, my opinion is informed by what I've read of European jurisprudence on this issue. And it's not just that it's 1 year, it's 1 year for any type of data for any purpose. So mischief, investigating, jaywalking, for example. I'm not saying that that's what they would do, but it's the fact that it's for any purpose, for any type of data, right, that creates a chill in people, that they could be under surveillance, that all of their data is being held for this long period of time. Right now, there's nothing that constrains the retention. Right now, it's any type of data for a year for any purpose, and I think that's what needs to be amended to make sure that it's more narrowly tailored to the type of data and the requirement in the investigative imperative.
If we want to share information with the Five Eyes, don't we need to hold on to data information, the metadata, as long as Five Eyes members?
In the Five Eyes, it's varied. For example, in the United Kingdom, they can only, in Europe and in the United Kingdom, it's only for serious crime. So it's not for everything that they can go and retain information for a year. In the United States, their authorities don't allow for year-long retention. That's not part of their act. And so every...
Désolé, malheureusement.
I'm sorry, Madame de Bellefeuille. Unfortunately, your time is up.
Mr. Lloyd, you have 5 minutes.
Thank you to the witnesses for being here. Dr. West, one concern that I've heard is that many tech companies advertise that they have privacy controls. For example, companies that have smart devices in homes advertise that the microphones can't be turned on remotely so that they can listen. Under this legislation, it's kind of odd to me that it talks about how it's content, it's not here to look at content, but that the ministerial orders can order these companies to provide the capabilities to turn on a remote microphone. Is that correct?
So where they talk about content, that's in terms of retention of data. So but it does allow for the creation or the ordering of intercept capability. So that would be an intercept capability. And now you could potentially have an order that would require that capability. And as long as it didn't create a systemic vulnerability, yes, it could be implemented. And they would have to change their advertising.
Now, that kind of creates a bit of a conundrum, because what if it's a secret ministerial order?
So, true. I don't have an answer for you.
So for the benefit of the committee and those watching, if a company says that remote microphones can't be turned on, and the government issues a ministerial order saying you need to build in the capability to turn on a remote microphone, the company in question could not change its advertising to say we will not remotely turn on your microphone without violating the very non-disclosure and secrecy clause. So they will still be advertising that they will not turn on remote microphones while the government has forced them to create that capability for law enforcement.
I'm not sure how a company would manage that situation.
It's just kind of an issue for me, I think. On another aspect, I'm concerned about blanket, you've talked about this blanket metadata. I can certainly understand wanting, like if you suspect that somebody or a group is involved in a criminal activity, that you could order, and I think that already exists, preservation orders already exist. But if we're talking about a blanket requirement that the metadata of all Canadians, and all people residing in Canada, be kept for up to a year, that creates a lot of very interesting constitutional, privacy laws. Do you have any thoughts on that?
I agree. I listened to the previous the questioning in the last testimony about whether or not this creates a seizure, and if it doesn't create a seizure, would it still violate Section 8? And I think the fact that there would be a serious chilling effect and a belief that people lacked privacy, because ultimately the state could then access through a subscriber production order, not a subscriber production order, but a transmission production order, a tracking production order, even location data for any crime going back up to a year, right, does create a chilling impact and would have serious implications for how people view their right to privacy in Canada. Yeah. And it wouldn't just be people in Canada, or it would be anyone who has services with a Canadian corporate company.
And I mean, I'm less concerned about the people committing crimes. I'm concerned about the innocent Canadians whose metadata is going to be collected. Are you at all concerned? We saw with the Salt Typhoon hack in the United States, where some very sensitive personal data was hacked by foreign agents, and it was discovered after the fact that it was the systemic vulnerabilities that were required by the U.S. government that allowed for this. If we create, I know the legislation says that it doesn't want to create systemic vulnerabilities, but I'm not sure that lawful access can be facilitated without creating. You said there's a risk. And then we're also talking about forcing companies to keep people's metadata blanket a whole country for an entire year. Are we not creating a treasure trove of people's personal data that hackers are going to want to have access to?
As I said in my opening statement, any point of access that is created that doesn't exist, and any pool of data that you're creating that doesn't previously exist, creates new risks. And so the regulatory framework.
Sorry to have to cut you off, Professor West. Avec les dernières questions.
Mr. West, final questions.
Final questions, Dr. Pawlowski.
Alors, j'ai besoin de poser une question.
Well, I need to ask a question in French.
Good to see you out there, even though you're on a screen. So I've gotten to know Darcy pretty well over the last few years, and I got to say he's a wonderful chief in Thunder Bay. I'm really glad you're here. You gave one concrete example of a 14-year-old girl. I don't know, maybe you can tell me after I finish posing this rather lengthy question, whether that was a real case. But I wondered about other cases that you've encountered, the public, or if you just want to disguise sufficiently who you're talking about, but other cases where lawful access would be helpful to you, I would certainly think in terms of child pornography, but I think especially in a place like Thunder Bay, there seems to be a real issue with trafficking people. There's also, as we both know, a big issue with gangs from Toronto, gangs from Ottawa coming up to Canada, or to Canada to, I guess you're Canada down here in Toronto and Ottawa as well, but coming up to Thunder Bay and committing crimes in Thunder Bay. There must be communications between the gangs back and forth between Toronto, for example, and Thunder Bay. Can you give other examples how lawful access would help you in doing your job in addressing these problems?
Yeah, thank you. So that case, so the real case, for example, is those youth that are coming up to us from down south. And we see them on a regular basis, some as young as 14 years old. And of course, we do have concerned parents that are reaching out and asking for some support, originally from Toronto Police and on to us, asking for some support to locate these kids. So really, when we're talking about the exploitation of these youth, they're getting involved in all kinds of different crime, gang activity. And I think that kind of the legislation, not the easier, but the more immediate access would be a real benefit to us when we're starting to see the chains, the links between some of the groups down south and these kids that are coming up here. It would be really beneficial to us to get ahead of it, especially when we're looking for these youth. I mean, we do have real life cases where we've had families come up and they've been asking us to go out and help search for the youth, and quite often we do find them involved in the drug activity or the gang related work that's being done in this community. So that happens on a regular basis. I'd say on average right now, we probably went from 60% to 50% of our people involved in that type of activity do come from Southern Ontario. And that, again, is very young people that are being involved and are exploited. We are looking at some of those cases. Are they human trafficking, or they are being human trafficked? They come in, they get into our fob houses, and then they end up doing all kinds of activities. So this is a real concern for us. And I think if we had the ability to access a little bit sooner, it would be a definite benefit to us to enforce some of the acts that we do.
Now, Chief, I could see in that situation where there are young people, 15, 16, involved in crimes coming up, and how you might want to be able to access their data, for example, on their cell phones, their internet, emails. But that's desirable, but there's a concern about the slippery slope. And although that may be desirable, how do I know that this doesn't involve, like, basically looking in on, I've got a 17-year-old boy. I mean, he's in a social circle. They have girlfriends. They're always socializing back and forth. How do I know that basically everything they do, including talking to Siri, doesn't go to the police? Which would seem to be an unnecessary violation of things that we think ought to be confidential.
Right, and I think police services across the country are very, very good at identifying the specifics of what they're looking for. So going back to my presentation, this is not about an overarching, wide open playing field for the police to go in and get what information they want. It has to be specific to the event that we're looking for. For example, if we have a missing youth from Southern Ontario, we would investigate that as a missing youth, and if we had access to their data and the material that they had, we may show those connections immediately that would allow us to start formulating a bigger investigation and the contacts and the associates that they have that may be in Thunder Bay or may be down in the Southern Ontario, which would really help us further our investigation a lot quicker and perhaps solve some of the victimization or even some of the illegal activity that they're doing. They would be very focused. It would not be wide open.
Ms. West, if I could ask you, and it did kind of, I hadn't thought about something like Siri, but that's internet data. If I jokingly, in response to my 16-year-old kid, he asked me something and he said, well, if you do, I'll beat you with a baseball bat. Jokingly, say that, and I mean, Siri picks that up.
Unfortunately, Dr. Pawlowski, that is the last thought of this round. I'd like to thank all of our witnesses for being here. We will suspend for the next witnesses to come on board.